What's up, viewers, subscribers, and agents alike? This your boy Enlightened Luciferian coming at y'all once again. This video is going to be detailing a lot of contractual obligations, more or less so, in regards to a binding agreement or something that's pretty much considerably a unilateral contract or one signature contract in regards to a person, or in the corporate capacity, a person in regards to payment or some other action. But before I proceed, let me proceed in saying that this does not constitute legal advice, nor does it constitute anything anti-government. The sole purpose of this video is for informational and educational purposes only. So now that we got that out the way, we can basically talk about why a lot of people who have taken out loans or who have actually signed something against themselves that's considering themselves a surety in regards to a financial transaction are actually held liable, even though certain entities who actually dispose of the documentation which you sign are actually the individuals who monetize and actually profit off of you actually signing something out that you weren't actually not monetized in your own personal capacity for. This is what we call commercial fraud. In any instance, whenever you sign something out against yourself, when you sign it, you make yourself what is called the quote-unquote the bearer or the holder in due course of the particular transaction. Now, when third-party entities such as auto dealers or credit card companies or what I call third-party entities basically take this documentation or take this promissory note, which is a promise to pay, which is a very certifiably, legally utilized document in any state or any municipality, is basically saying that they're the ones that are taking on the responsibility because they pretend to be the underwriter for extending the loan to the people who actually sign the documentation. Now, whenever you have what's called a documentation or a contract, you are considered under UCC 3149 as the accommodation party. Anything that's extended to a person who accommodates the documentation is considered a person who is actually not only the bearer, but also the liable party for actually, making good payment on the particular contract, which is what they call operating in good faith. However, any contract that is ever extended to a person who doesn't particularly wish to actually endorse it without reservation of rights is an individual who is totally liable. And since you didn't reserve your rights, those people who are the third-party entities who wish for you to actually, use your signature for monetization are using it for the benefit of making themselves the beneficiary and making you the trustee. Now, there's one particular way in which you can actually absolve yourself of actually being liable for it. And there's another way you can actually absolve yourself from being liable for it too. It's because that you first, when you sign it, you reserve your rights. And then secondly, once you reserve your rights, you also give them what is called a notice of claim, or you also give them what is considered grace and notice. Now, everyone has their legalized theories about this, but in the respective private capacity, you're only supposed to do this in notice form and then affidavit in the private capacity, because now you're giving them what's called grace and notice, which according to Truth in Lending Act, which is a 72-hour period from the time that you actually execute the contract, these people have to actually make themselves legally responsible for answering you within the 72-hour period. Other than that, that means that the contract that they actually extended you was invalidated, which means that it is no longer legally standing in regards to commerce, and in commerce, truth is sovereign. So if they're actually telling you something that's fraudulent in regards to how they execute a contract, you're not responsible. Just think, most people, especially at a time like today, take out, thousands of dollars in home loans, or they take out thousands of dollars in loans, period. But at the same token, the entity that actually extended the loan, who was actually accredited by a federally deposited insured corporation, such as i.e. a bank or whatever third-party entity they wish to contract with, they are extending the monetary evaluation to you. But when you sign a loan, they take that monetized value and they deposit it into what is called a liability account. And then what they do is they monetize it based upon the liability side, and they get paid. So when they send it to a debt collector actually pays for the debt. So once the debt collector pays for the debt is actually absolved. You just need to ask them for the original contract in order for them to actually give it back to you, because they sent it to the debt collector. Because if that was the case, the debt collector would have never contacted you. Once you get that original contract, you take that and you actually include it in the UCC3, and you actually take that contract, you attach it, and you send it back to the individual that says you want payment, and you don't have to pay those people at all, because what they did was fraud from its inception. And you just learned a very significant truth in less than 6 minutes. Now, a lot of people might qualm, or have some sort of variance of what I just said, but because these are people who are complacent, or they are quote unquote categorically placed in their own ideology of what society is in regards to it. The situation is this: these people have took this particular promissory note and they monetized it, and they made sure that you particularly could not or would not operate in good faith. But they must give you the original contract, because in order for any contract to be valid, there must be full disclosure. So people, hold on to that, and make sure that as time comes on and time consumes, every time you sign a loan, make sure you reserve your rights and tell the entities in which you actually sign with to give you the original contract, because you signed it. That means it's unilateral, and that means that a one signature contract can never be validated, because any contract to be validated has to be signed by 2 or more people. Now, lastly, if you sign it with a bank or a financial entity, that doesn't mean that the contract in which you sign is valid, because it's between a corporation and a corporation. Now, if you're signing as a surety, then that means that you're signing as a surety in your natural capacity. That means that you have to actually give what is called an accommodating note. An accommodating note is something that you actually attach to it to actually indemnify yourself from actually being penalized for non-performance in an act of forbearance on behalf of a third party, and which is why insurance exists. Y'all better stick with it. Peace, light, love in less than 10 minutes. Y'all go ahead, just keep on rolling. YouTube shadow banning me. It is what it is. It's fine. Well, let's talk about the law of obligation. I'll leave off on this note. A binding agreement committing a person to a payment or other action. Notice what I said, payment or other action, which means that any way that they can try to get it from you, they will get it from you. And if you can't give it to them, and they actually try to take it from you, they will. Which means that property, assets, and what is called also forfeiture. Because whenever you commit a fault in commerce, it's called commercial bankruptcy. Y'all stay tuned. We burning their ass up. And YouTube, unfortunately, they don't like for me to be famous. I don't plan on being famous. I don't ever want to be. But it is what it is. I'm keep giving the truth. Hey. Fortunately, like I said, I don't have a series of law books behind me, or, degreeage or so forth and so on. But, I'm just a man that loves to read. I understand the intricacies, understand, and understand the intricacies, and just make sure that they can't use it against me. Do the best I can. Stay above and not underneath maritime law, but above water in positive function. Y'all stay tuned. Peace. Agents, do not contact me. I do not consent, nor do I oblige. Y'all take care. Stay tuned for the next upload.